Okay, welcome to Quillian's Kernels. This is Henry Quillian and Natalie Mark at Taylor English Duma. And as those of you out there in the world know, Taylor English Duma is not seeking to provide legal advice to you, but rather is a tool by which you might get ideas to go investigate your own legal procedures using a lawyer when appropriate. We are here today discussing the use of video depositions at trial and also the steps necessary to get video depositions that are useful for trial and to take video depositions that would actually be usable in an effective manner at trial. And so we're going to be interjecting some of the video clips to give examples of various things. But we've got to start with the basics, which are what kind of depositions are there generally available? And you may know that we, for the most part, concentrate on Georgia civil procedure, but as it turns out, throughout the states, in the United States, there are various use of depositions that may be available that might not be available in Georgia. So one of the things that definitely needs to be considered is what state or jurisdiction will you actually be using the depositions in, because the rules may vary as to how much you're going to be able to use of a video deposition or how little you're going to be able to use, depending on what sort of case it's in, what trial court it's in, and even specifically what judge you have. So if you have local counsel in a foreign state, you better read the rules for that foreign state, but also try to find out what the judge is likely to allow you to do or not do with your video depositions. So Natalie, what type of depositions are there?
Okay, so everybody probably knows about the discovery deposition. That's the deposition you generally take to just find out what the other party knows. You ask all kinds of questions. You're just probing that witness to find out everything you can about them to help you with your case. But what you may not learn in law school or in any school is about the preservation of evidence deposition. And that's different from the discovery deposition in the sense that the preservation of evidence deposition is normally taken because you know that a witness is not going to be available for trial. So you know that you're going to have to play that deposition at trial in lieu of that witness. So that's generally the two different types of depositions, but sometimes you also will have a hybrid where you may have taken a discovery deposition, but then that witness becomes unavailable all of a sudden. Maybe they have an accident and they die in a Porsche or something like that, and then you have to take that specific discovery deposition and turn it into a preservation of evidence deposition. So those are generally the types.
Which can lead to the issue of, particularly if you have particularly old witnesses or witnesses that are sometimes in state and sometimes out of state. They have a vacation home they live at a lot, or it could be in the course of a discovery deposition. You find that these people are preparing to retire and move to their lake house in a different state, or that they have some serious illness. You might have to switch modes to some degree while you're actually taking the deposition, if it's a non-party witness and you're just learning this information, in order to make sure you have your evidence at trial in a manner and a form that you would actually want to use it in. Which gets to the issue of videos versus transcript depositions. What we found, or what you may find with respect to transcript depositions, is they are pretty challenging to use at trial and make it at all interesting to a jury. You might be able to use a transcript to effectively impeach a witness by getting that witness to read the contrary answer to what the witness just testified about. But if you were to try to just display, for instance, on the screen, the testimony of a witness that had been given it, you never know if the jury's actually reading it or not reading it when they're looking at it, and what words they're concentrating on. And also, it can just be really stilted. Sometimes you have to hire an actor or somebody to actually read the deposition for you if you've got somebody you want to sort of fit the mold of the person who would otherwise be giving the testimony, because It's obviously dreadfully boring for a lawyer just to stand there and read a deposition to the jury. And so you have either video depositions or just pure transcript deposition. And of course, video depositions are a lot more expensive because you have a videographer there who you have to pay to do the video, but sometimes they can be worth their weight in gold. And then within the video depositions, you want a video deposition that if there's any probability of the case going to trial, that you can slice and dice fairly readily for use at trial. Because if you just have, I guess, what we referred to, I need to get RoseAnn to come over here too. If you're inside the green dots, you're inside the video. This is RoseAnn Annesi, and she was our litigation support specialist in a recent trial. And she has some comments on the use of one type of format versus another as far as actually usability in the trenches at trial.
I think the most important thing is when you are taking a video deposition, you're going to show up at the deposition and the court reporter is going to ask you, in what format do you want this in? Do most of you know what format you want this in? The most important thing is that the video does come synced. Most court reporting agencies do provide that with you with the price of your video deposition. If not, there may be an additional charge for it. And the reason I say this is that it's Sunday night right before trial. It needs to be synced in order to make a clip. Most often than not, they're going to say, do you want it on a DVD? Well, for any of you that have children or watch movies, a movie is a DVD, correct? A DVD is also a data disc. So they're taking that as you want a DVD. You actually, what you want is your synchronized video burned onto a DVD, not a DVD. So if there is some confusion when you get it, the most important thing is to check it. And usually if you check it on the back and you have lots of folders, you're fine. You want an MPEG, you want a CMS file, there are different files. But if you open up that DVD and you put it in and you can only play it on a DVD player, that'll be a problem if we have to edit it go forward. So that's important to know. And
it's extremely expensive after the fact to take a DVD and have it synced.
Yes.
And also, I mean, if you're like me, when the deposition comes in, I think of it, oh, that one's done, that one's in the bag. I personally have not gone through and looked at the files that were on the disc and try to find out what kind of video it is.
Yes.
That apparently is unadvisable. Somebody needs to be checking that so you're not caught short when you actually need to use it down the road.
And there's several things you should be checking. Moving it along quickly to make sure the volume is the same, because normally sometimes your section 1 was high, 2 was low, 3 was high. We need to get it all one volume so that we're not sitting in a courtroom and we're turning the volume up based on the different parts of the video deposition. That's really, really important. And again, back to the pricing of the syncing. If you receive a DVD and the video and the deposition is not synced together, that can run, based on who your tech is or who your court reporting agency is, anywhere from $35 to $100 per video hour. That's where court reporting agencies make their money, okay? If they're going to give it to you free and it's going to mean you need a videographer, go ahead and take it, because in the end, those bills can really add up to what it costs to have a synchronized video.
Okay. So there are really two uses of video depositions at trial. Well, really, there could be many more, but there are two basic uses. Two basic uses are, and the one that's most well known, is taking what you learned in a deposition. Let's assume for the moment it's a discovery deposition. Your witness is available for live presentation at trial, and it's to impeach that witness. You've gotten some great testimony during the deposition. You need that testimony to prove your case in chief, let's say, and you're cross-examining this witness and they start saying the opposite of what they said in their deposition. And so somehow or another, you need to make sure the jury hears the part of the testimony that's supportive of your case, not the part that they're all of a sudden getting up there and destroying your case because they're telling everything just the opposite of what they said in their deposition. So what you would typically do there, and as a prerequisite in this instance, this use, you need to have a prior inconsistent statement in order to present to the jury. So if the witness gets up there and says the light was green, and you know in their deposition that they said it was red, and you want to prove it was red, then you're going to need to use that deposition to cross-examine them. Now, historically what you would do is you would take the book up to the witness and hand it to them and say, didn't you say in your deposition, show them on this page that the light was red, not green, etc. Now you can just leave the witness sitting there on the stand and ask your trial tech, play clip number so-and-so, and it'll show the same witness testifying just the opposite at the deposition. And then you could either do follow-on questions like, well, wasn't the deposition 5 years ago right after the accident and here it is now? Or you can use some other mechanism to try to make the jury believe that the witness was more credible back then and was telling the truth back then and is lying now because of whatever influence. And sometimes you can use the same clip over and over again for impeachment because it might be a sentence they say and different parts of the sentences address different aspects of the new testimony that they've given. So that would be the more traditional use of a deposition under the Georgia Rules of Civil Procedure. The other one that's traditionally used is for preservation of evidence at trial and actually presenting the witness at trial. Now, if you do present a witness at trial, what characteristics would be good in the presentation of a witness at trial? Any ideas? Ideas? Well, let's throw out one and then I want to hear some answers from the audience. First of all, you want it not boring to the extent possible, right? Who's going to be listening to this? Who listens at a jury trial to the depositions?
The jury. Hopefully the jury.
The jury, yes, the jury. Hopefully the jury. So if it's dreadfully boring, then the jury's not going to want to listen to it and see it as in the same manner as they would if it was at least moving along at a reasonable clip. What does that mean before you go into a deposition? You need to be organized. You need to have your documents lined up if you have to use exhibits to cross-examine the witness or if you need to authenticate documents. And you need to have a lot of documents. If you want to get that witness to testify the way you want them to testify at trial, what are you going to need to have available to cross-examine them with? Let's assume for the moment it's a hostile witness. What do you need to have available to get them to testify what you think they ought to be testifying based on the written record that you've obtained in the documents? What? You need the documents to use to cross-examine them, right? We're talking about preparing, talking about taking the deposition for use at trial. If they've sent a bunch of emails, you need to have a way to get to the emails that lead them down the garden path to the answers you want them to give readily at hand. So when they start saying something opposite, like I never knew who this person was, and you know there's email traffic back and forth between that person and the person, they have no idea who it is, then you can bring them back on course. You can also use their correspondence. You can use contracts they've signed, on and on and on. So you need to be prepared to move along. Now, what if you get all the documents the night before and you've had a chance to read them, but you haven't had a chance to organize them in a way where you can, for instance, use a keyword search on a computer to find a specific page? Well, one thing you can do when you're taking this person's deposition is if there's a blank space where you're trying to find a document in the course of the video deposition being taken, you can either take a break and then start back up again, right? Or you can, I would say, provide a little commentary on the record. Like, I'm looking for the documents among the pile of documents I got last night or something, so the jury will know what it is, why it is that you got this long break that's going on. Because otherwise, the jury's going to totally lose interest and start thinking about other things. Excuse me?
Or you edit the deposition.
Well, Randy has gotten to a point that is very important but very inconsistent, I've found, among courts. Some courts, particularly if the other side says, we want the whole thing played, some courts won't allow you to chop out dead space or objections from a deposition. Obviously, if you have a long deposition that's got a lot of dead space and a lot of objections that are not sustained or never are asserted by the other side, if you can chop out those, then you can shorten the length of the trial, shorten the length of the testimony, and make it flow better. Sometimes, of course, you want the witness to be sitting there looking dumbfounded, but sometimes you want to go ahead and get that out so that it doesn't take so much time. So when you're taking the preservation of evidence deposition, be very cognizant that you basically are on the stage and you are trying to impress a group of 12 people with your ability to get evidence into their heads, and so try to keep the clip going. The other thing you might want to do is, if you can, find out what the witness might say beforehand. But let's assume for the moment that it's a third-party witness who has an attorney who only by subpoenaing the witness, you're able to get the person to the table, and you have no idea what this witness is going to say. You can only know what the witness should know about. We've got an example we could show. This would be the VAR Reeve one. That was pretty funny because it's a guy who was not prepared for testimony.
You didn't know you were the sole owner of the company you were the president of?
That's correct.
So there's an example of a witness. You're like, could this really be the case? A witness who owns and runs a company but doesn't know he owns it. Sometimes that can kill you, of course, when you go get this testimony. You wish you'd never subpoenaed the person. And sometimes it can help you because either they're being so evasive that the jury's never going to believe what they're testifying, or alternatively, they do know the one thing you need them to know, which is oftentimes what you want to be asking in a preservation of evidence deposition. Only those things that you know you need them to testify about.
You've got a situation where you have a witness that you know you're going to take the preservation, but you don't know what they're going to say. Can't you notice back-to-back a discovery deposition and a preservation deposition on the same day, and do them back-to-back?
The question is, and I believe it's probably picked up, is can you notice a back-to-back discovery deposition and then a preservation of evidence deposition? And the answer is generally that's true. You can do that. It works better with experts sometimes. And if the other side, if the witness doesn't object or the other side doesn't object or move for some part of protective order, then you can try to find out what the witness is going to say before you have them testify live, basically, for the preservation of evidence. Now, sometimes you have to decide what you want to do there, because if you think you're only going to get the good testimony once, and once they realize what path you're on, they're going to change their testimony, and you don't have the discovery deposition to cross-examine them with, then you preserve the opposite of what you want, basically. And so some of that depends on how good you think you'll be at getting the testimony out first time around. Got any comments on that?
Well, I actually had an experience where I had to take a preservation of evidence deposition, and then the other side objected and said, hey, I don't want you to take that. I want to first do a discovery deposition. And I researched it for that jurisdiction, and of course you can do that. So I said, fine, take your discovery deposition, and then I'll take my preservation of evidence deposition. But when I actually flew out there to take the deposition, they decided they didn't want to take the discovery deposition. And they said, go ahead, Ms. Mark. And I was like, well, didn't you say you wanted to do this? So that's where it helps be prepared and be organized and be ready to go no matter what. So, but you're 100% right.
And you always have the issues of just expense. But obviously, bad testimony can be a very expensive thing to have happen to you. So that's something to consider when you're taking the deposition. Obviously, if you have a chance to prep the witness that's helpful, or to learn, like if it's a non-party witness, to try to use their attorney to help you prep as to what the person's going to testify, so it doesn't come out in cross-examination that you met with the person the day before and told them what to say, or you never know how the witness is going to recharacterize your meeting. So that could be devastating regardless of how good the testimony is.
And there was something else that occurred to me for the first time, where I had a witness, while I was deposing the person, break down and cry. Like, she just started bawling during the deposition. And I was nice. I mean, I wasn't saying anything to like cause her to cry. And I was, but I mean, you don't learn that in law school. You're trying to figure out, well, how do I deal with this lady? She's bawling, she's crying, and you want to appear sensitive, and I am a sensitive person. So you want to, if you're not a sensitive person, then you at least want to appear sensitive, especially if it's a preservation of evidence deposition, and they're going to hear your voice on the screen when you go to trial. So that's something that I had to, figure out, because I was like, well, maybe I should just do a break right now. Maybe this is helpful. Maybe I should just let her cry and hand her a Kleenex. So you have to figure out how it works best for your particular case. And I also had somebody break down and cry at trial. And I also had to, figure out how to handle that. But fortunately, I had the experience already in the deposition. So I knew that that was likely, and I knew how to handle it much better. But you definitely want to be sensitive of the fact that, you don't want to be mean or hostile or whatever, especially if it's a preservation of evidence deposition and it's going to be played for the jury. And they're going to be like, I liked her until I saw that. So
I have a real big box of Kleenex I carry in my deposition prep kit. So, and I have other things in there too to protect myself if the witness gets really mad at me.
Do you have a box for the witness, or is that your box?
Well, it depends on what I want the witness to do. If I want the witness to cry, I'll start crying along with them, because I'm not on the video. So you never know what's going to work. Remember, it's in a sense, it's a show. At the end of the day, obviously you don't want to lose credibility, but particularly if you've got a super long jury trial, you've got to keep them engaged somehow. And you don't do it for showmanship purposes, but you do it to try to make things a little more interesting, like not just using a monotone voice, asking every question, reading them off the page, but rather using voice inflections, or going, really, or whatever you might need to do. Could you? Yes.
The time limits for depositions under the rules of civil procedure, my sense is they don't apply to preservation of evidence depositions. Have you ever seen a ruling to that effect?
I've never seen a ruling on the time limits for a preservation of evidence deposition. However, I've never even thought about that, taking a preservation of evidence deposition longer than 6 or 7 hours.
No, my concern is you've already taken a discovery deposition for 5, 6, 7 hours, and now you want to come back and say, now I want to do a preservation of evidence deposition. To what extent does the witness have the right to object, saying you already used your 7 hours?
I think the witness can always object. The question is, will they win? but I really have no idea. That's a great question. I've never looked at that whatsoever.
Well, there's some courts that give you a limited amount of time to present your case, period. So you have to be mindful of how long your preservation deposition is going to be, because you could be burning up more time than you want.
You don't have to use the whole thing.
That's right. What Foy is just talking about is the court may say, you may think you have a 3-week trial. They may say, no, this is a 1.5 week long trial. And they're going to, and all of a sudden, all your testimonies need to be shorter than you anticipated. And so if you've got depositions and there's the other side saying you have to play the deposition in toto, then you got a big problem if you've got a lot of dead time or the deposition stretching out. Yes, Mark.
I had one recently in the District Court of Maryland, where in the scheduling order, they gave the total number of hours of deposition for each side. So it wasn't limited to 7 hours per deponent. It was, I think in our case, they limited it to like 12 hours total per side of deposition time.
That would be extremely challenging if you had all out-of-country or out-of-state witnesses. And I imagine you would have to make a good showing to get an extension of time if you had to prove it and had to use more time in order to prove your case. But yeah, I have seen that where courts try to crunch down, or they say you get X number of depositions and that's it. And people, that's the case. As soon as you agree to that, you're going to go take the witness that you think knows everything, and that person's going to say, I don't know that, you'd have to talk to so-and-so. I don't know that, you'd have to talk to so-and-so. That seems like that's always going to happen. We had a witness who gave some pretty strong testimony, and he was somebody who wanted to fight through, I guess, virtually every testimony, but at the end of the day, he ultimately came through.
Make my day. We just got a building back with $4 million equity in it.
All right, well, so at the end of the day, this guy, if you sometimes if you pound on a witness for long enough, they'll just start basically saying what their true thoughts are, and that was a circumstance where this guy had put up every kind of resistance, and then finally he just said, this is what I was really thinking at the time. But one of the things you don't want to do if you're taking a preparation deposition or preservation deposition is to talk over the other lawyers and just try to, it's very hard if you've got a videotape going to remember this if you're getting all upset. But you want to remember that at the end of the day, somebody's got to actually hear what the witness is saying. And we've got a little clip here of lawyers totally bickering with each other, and it does not make a very good presentation.
Don't guess. If you have a reasonable estimate, that's fine, but don't just guess.
Well,
Mr. Barber,
within the past year.
He's
Okay.
doing just fine by himself. There's no reason to help him unless he needs it.
Well, I think that's my job
I can't,
here.
I can't give you a date.
The job is to let him testify
Sometime-
from his own memory.
He can testify from his own memory. I just don't want him to guess. You don't want him to guess either.
Well, if he will nail down what he knows and doesn't know just fine.
So, see, that wasn't very effective for preservation at trial. And at the time this was taken, it probably may or not been taken for that purpose, but it was a video deposition. And the lawyers were just all over each other the entire deposition, and it ended up being 400 pages of deposition, which these are not our lawyers. This was taken in another case. And so there wasn't much we could do about what had happened back then. But what you can do about, though, is sometimes you have a witness show up and they have an attorney with them. And that attorney is going to be I'm the new sheriff in town attorney. And they're going to try to control the deposition and prevent the witness from testifying regarding what you have the right to get discovery on, and or try to change the witness's testimony because there's some liability that the witness might have. And you've got to take control of the circumstance. And we had a case, I've had a witness where the attorney showed up, and I kid you not the opposing attorney, but on every question, it was objection to the form, same objection, cause for speculation, blah, 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 just one objection after another. And so finally I had to try to put him down.
I just had a couple questions to clarify the record.
I don't believe that you are here to ask questions. I believe only the people in the litigation have any right to ask questions in a deposition.
And obviously the witness did not know what was going to happen. But on the flip side, you have to make the decision. If you've got a witness's lawyer who's causing all sorts of grief, and you're in some foreign jurisdiction where you've managed to subpoena the witness, what do? Do you go ahead and plow forward with the deposition, try to go ahead and get the testimony wrapped up, or do you try to find the court that issued the subpoena and figure out how to get a ruling issued regarding shutting this attorney up, et cetera? So it can put you in a pretty tight spot. And then sometimes you just have to preserve the record and tell the witness at the end of the day, well, because your attorney has instructed you not to answer, or your attorney was so obstructive and I didn't get all the testimony I need to get out of you, you just need to write, basically form a record, and you might have to come back and take another deposition of the guy after you get rules of the road laid down by some judge. Because we did actually, I've had that also where the attorney just says he's not going to testify about that. And if it's a collateral issue and you got, you're out of town, you got limited time, you got depositions you got to get to the next day or something, there's only so much you can do if the attorney is telling the witness don't answer. And you have to get some other testimony from that witness. Now, another thing to be very cognizant of is ambient noise in a video deposition. For instance, if you have a jackhammer going on outside the room where you're taking the deposition, as one judge has put it, video microphones are not do not have selective hearing. And so if the witness is trying to testify and the lawyers are trying to ask questions and all the jury can hear is a jackhammer going off, it's obviously extremely distracting. And so you need to be real aware of that and just move to somewhere else or do something, because in a sense you're a choreographer of this whole scenario, and if you don't take charge, nobody else is. And you've got to, especially if you're going to be paying thousands of dollars to get this deposition, you can't tell the street crew to turn off their jackhammer, more than likely, but you might be able to move to the other side of the building or something.
And just in addition to that, especially if you're taking a preservation of evidence deposition and you hear a jackhammer or you hear this noise, you might want to simply state that into the record, because the jury needs to know what that noise is. And sometimes if you have to play back that deposition and they hear this noise, they think it's you or it's your crew that's messing it up when it's actually a part of the deposition. So at the time that it occurs, you might want to say, yeah, sounds like there's a jackhammer here. Maybe we should just take a break and see if we can get that distraction or that noise taken care of, so that at least if you can't, the jury understands where the noise is coming from and why it's occurring. And it also might be helpful if you're taking a deposition, a video deposition, and you're playing it back for the jury, to have the words on the bottom so that they are not just relying on hearing it, because you don't know what kind of courtroom you'll be in. And if you're in a really large, massive courtroom, the sound may not, they might not hear it as well as you think they would. So if they also have another option of reading it, then that could also solve the problem. So it's just something to think about.
It has to be synced for that to work.
Right, it has to be synced.
As long as a video is synced, you're able to use the closed caption on it, as she said, if they can hear something like that. And also closed captioning works really well if there's a language barrier. Okay, but if not, you really want them focusing on your witness. You want them to see their facial expressions when they're not sure of an answer or what have you, but do remember that option is there as long as the video is synced, yes.
Now, one thing that's particularly difficult in commercial litigation is the fact that lots of times documents are referred to in a deposition, and it could be in any kind of litigation where you need to use a document to cross-examine the witness, and you have only a limited number of options there as to what to do when you're presenting it at trial. One of the things that, if it's a provision in a paragraph and you're taking in a contract and you're taking a preservation of evidence deposition, rather than just telling the witness to look at paragraph F and tell you what that means, you might want to actually read the paragraph to the witness or the particular sentence that's critical, so it'll all be incorporated as part of the deposition. Because if you don't, the jury is going to have no idea what you're talking about or what the witness is talking about.
You can put the document up on the screen next to the witness.
Well, Mr. Ross has suggested you put the document up on the screen next to the witness. Now here we're talking about a preserved video deposition, so that leads to several possibilities. First of all, if you have two different display screens, such as the computer playing the video deposition, and you also have an Elmo, which is basically an overhead projector you can put documents on, you can use that, if the court will allow you, simultaneously with the witness's testimony, so that you can show what provision of the paragraph, of the contract they're talking about. Or you might have a dual screen situation where you can present the document and even have a trial litigation support person highlighting or circling the area of the contract that's at issue while the depositions going forward. You've always got the problem of, are you going to distract a juror from listening to what the testimony is? And I don't know how to even resolve that, where you've got, if you get the jury totally focused on one word in the contract, they don't hear about what the testimony is, that's no good. But the other thing you could do is, if you've got lots of documents you're going to be going through, and maybe they're lengthy documents, but the witnesses, you're just touching on this, touching on that, trying to get some cadence and trying to basically get the overall picture of what's going on using various provisions in the contract. You could give, with permission from the court, give the jury a notebook for that witness. Obviously that could be really expensive if you had a big jury and you had a stack of documents, but you could give the jury a notebook for that witness, and hopefully you have some correlation between the exhibit number and the tab numbers in the notebook, so they could look at the contract as it's being considered. Or it might be just fine if it's just a short email where the person makes an admission or something like that, where they're not likely to get totally caught up in the document or look at it and go, oh my gosh, that's got so many words, I don't even want to look at it at all. So the other thing you can do, and this is what we actually did in the recent trial, was do the entire video deposition, at least the portions that were allowed by the court, and then display the exhibits afterwards. And that worked out pretty well, because what we did was we took a laser pen, and frankly, I'm happy the other side didn't object, but when we went through the contracts, I could circle and basically underline using the laser pen the provisions of the contract that were the important ones and that the witness had just testified about. So that gives you the opportunity for the jury at its own reasonable pace to read what it is that the witness has testified about, so you could see what they were talking about. With respect to objections, under the Georgia Rules of Civil Procedure and under federal rules, you only have to make certain objections during a discovery deposition. And presumably, you are preserving for use of the deposition other evidentiary objections. However, I found the court that we recently went before basically would not countenance an objection unless it was in the transcript, or unless there was some other, if you could still raise evidentiary objections or file a motion in limine, but as far as going through a transcript and deciding what was going to be heard or not, if there was no objection, then you had a problem. And so you've got to know, to the extent you can, what your judge is going to do as far as deciding what testimony gets to be heard versus what's purely discovery information, and make a determination whether you need to object or not in connection with your preservation of evidence depositions, definitely, and then also during your discovery depositions. And so literally, when somebody is taking a deposition this becomes a preservation of evidence deposition, you need to be cognizant of whether you need to go ahead and make your objections to such things as a leading question or relevance, because a judge might find down the road that if you didn't object then, that you waived it, and that would be potentially bad.
Yeah, and I had an experience where I objected during the deposition, and that particular issue came up, and the other side wanted to play back that video deposition, and they wanted to play back the portions where I objected, and then the judge was forced to have to hear why I objected, and he ruled in our favor with respect to that issue because I had objected. But if I hadn't objected, then the other side would have gotten to play free for all everything that that they asked, even though it wasn't relevant or important or whatever.
Did you state the basis for your objection in the deposition?
I did, but the other side did not. So in that jurisdiction, it does not appear that you had to, but in some jurisdictions you may not. But I did, just because when you have to go back months later after you depose somebody, you don't even remember why you objected. So for me, it's more helpful to know why I objected unless I don't know, and then I just object and hope I can figure it out later.
When you have a videotape deposition, a lot of times you get a number of objections, and you have to raise things like hearsay and everything else, which really clutters up the record. A lot of times what you can do is have an agreement, and you should have this in advance anyway, as to how you'll handle objections or any other problems. Sometimes you can have one party just say objection, then you go off the videotape, then you can argue it out in the transcript back and forth, whether it's hearsay or not hearsay or whatever the objection is. And that's for the judge to read and rule on. And then you go back, and all you have is the witness testifying, then Henry stands up or says objection, go off the video, and then you come back and then you do that too.
That's clearly the preferred method, and the other side will agree to it.
Okay, so what Randy has just described is a mechanism by which you go off the video record to argue out your objections before the witness starts testifying again. Now, obviously, there's not going to be a ruling on that, but at least the judge will know what the basis for the objection is when he goes back and reviews the transcript. And you will, as Natalie was pointing out, you'll actually remember what it was you were objecting to at the time. When you
Most times judges will say to you, if you're going to introduce any depositions in trial, I want the parties to designate those portions which are coming in and those portions which aren't. And so if it's something that's irrelevant, then you don't even have to include that portion of the video deposition, assuming you've got the synchronized stuff where you can coordinate everything, and you just leave that out. Or you say, here it is, Judge, here is the question, here's the objection, and then you can point out to the judge, this is where we need a ruling, and he does it ahead of time, so your videographer can then play it through without interruption.
Yeah, it's certainly preferable for the judge to rule sometime ahead of before you're in front of the jury as to what portions of the deposition the judge is going to exclude. So sometimes they'll do that the morning before testimony starts. Sometimes it's in a pretrial order weeks before the trial, which may well be preferable. Of course, one bad thing there is if you've realized you need to have something that you just agreed to chop out because you didn't think it was going to be important because you thought somebody else was going to testify a different way. But with respect to use at trial, one of the things we tried to do when presenting the recent trial was intermingle video depositions with live witnesses so that we never had a full day of just people on the video screen. While if you got a really entertaining witness on the video screen, it might be okay. But if you have some that are just there to get some sort of technical facts into the record or the like, the live witnesses are far preferable to video. And of course, video is far preferable to reading a transcript unless you got a really good actor doing it for you. So that's something to keep in mind is how are you going to lay out your trial so you keep the interest of the jury along the way. But the other thing you need to do is lay out the trial so that you can put witnesses in that will either contradict the other side's previous witness and be more persuasive on the point than that other side's witness, or alternatively try to forestall a bunch of cross-examination that the other side might do with your witnesses if they are not concentrating on the fact they're going to get blown out of the water by the witness that you're later putting on. So when you're doing your preservation deposition, obviously you should not just be going off of a transcript of questions. You need to listen to the answers that are given by the witness. And if they only give half the answer that you expect to get from your question, you need to go back and ask the second half of the question. You need to be engaging with the person who is going to have this camera right in their face so that you will ultimately piece together everything you need out of that witness for the trial, because once that videotape turns off, that's all you're going to get out of that witness unless you can induce them to come to trial. So that's clearly something you need to think about. Don't just read questions off of paper and expect that you're going to have a good video deposition.
So in conclusion, because I know our time is up, I know there's a lot of other things that we could talk about. One quick point that I want to mention is that when you are doing your depositions, and if you think your case is going to trial, it's very smart if you do a continuing number exhibit list, so that you already have, for instance, if you take 10 depositions and you have 100 exhibits with respect to those depositions, you already have those 100 exhibits ready, so that when you get ready to go to trial, your first 100 are those depositions, and then you can add on to it. And RoseAnn, if you want to touch for a minute and talk about that, and then we'll.
I think that's especially important, especially if you are preserving your witnesses to be used at trial, your videotape, because then you're not worrying about if Exhibit 10 is now Exhibit 55. So the numbers stay in line, and it's half of your pretrial order. It's your exhibit list, and that's how much time you saved. So why not, you're hiring the court reporters, allow them, tell them initially on your first deposition you want continuing number. They should provide you with the list at the end that gives you the numbers, what the description is. Half of the battle is done. So that's a really good way to save time and money and to be prepared and know really what the numbers are without confusing the jury. Well, 1 is 500 and 6 is this. So this way then it's also very easy for your paralegals and everyone who's involved in trial prep.
Yeah, and if you know you're going to trial, if you know it's a trial that's going to be very document intensive, then I think it's imperative and it's more cost efficient to even have a paralegal or hire somebody like RoseAnn to make sure that your exhibits are in line and in order, because it's going to cost you more money to try to figure out, well, which one was the deposition exhibit from that deposition that's now the trial exhibit, and you got to sit there and figure all of that stuff out, or you have to have somebody figure it out, and it's just more costly to your client. So if you can explain to that in advance, if you think you're going to trial, hey, if we go to trial, this is actually the more cost-efficient way to handle this, because we'll have somebody who can, streamline it, and you don't have to do all this other work. But in closing, I would highly recommend somebody like RoseAnn. She was excellent. We had to stay up all night finding these clips and organizing our cross-examinations and making sure that we had a clip for that. And in case they said this, that we had another clip to contradict that. So it was definitely something that I don't think attorneys could do on their own. I mean, maybe few gifted ones, but it's certainly not something that I could do. So it was imperative, and it was more cost efficient to have somebody like a RoseAnn, who's a litigation specialist, to do that.
And were you allowed to use video excerpts in your closing argument?
Yes, actually we failed to mention that. We were able to use, the other side actually used video excerpts from preservation of evidence depositions in their opening, and then subsequently all of us use them, both sides use video clips in the closing argument, and that can be very, very effective, particularly if you have a witness who repeatedly says the same thing over and over again. You can play each clip, or you can play the same clip numerous times. Closing argument, there's definitely theatrics associated with it. And so
there's an argument that that's giving undue weight to the videotape deposition testimony as opposed to testimony from the stand.
Yes.
And when we tried a case in front of Judge Thrash last year, he would not allow video excerpts to be used in closing argument for that reason.
Right. I guess I'm not going to say what I agree with or don't agree with on this video, but let's put it this way. If you play Make My Day over and over again, it's going to stick in the jury's mind reasonably well, and then I guess you would go from there. The judge may have to make some determination in advance whether you could abuse the video clips by making it into like a rap song or something where you say the same thing over and over and over again as part of your closing, because in a sense you are doing theatrics and you're obviously trying to get this information into the jury's mind. So.
Just to that point, I did have a closing argument where there was a witness who for 5 hours just said, I don't know, I don't know, I don't know, I don't know. We actually played I don't know for about 4 minutes flat, just I don't know. Then opposing counsel absolutely objected during closing, and then the judge allowed it to come back on, and then we fast forwarded it and we slowed it down, and we just kept playing I don't know, I don't know, I don't know. So absolutely.
Apparently this is a witness that's supposed to know a lot, I suppose. All right, well, thank you very much for coming to Quillian's Kernels, and appreciate you being here.